So you are asking me about the position of the Chinese language in the present Hong Kong legal system. Well, obviously, the pre-1997 position is that English is the sole language that is legally recognized as being official in the practice of law. And now the 1997 return of sovereignty obviously has caused some changes, understandably in recognition of the change of sovereignty, and so as to give back to the Chinese language the status that it should have. The Basic Law makes provision in its Article 9 for that purpose, to the effect that post return of sovereignty, the Chinese is to be the primary legal language, or the language of the law. That is, in terms of theory, obviously. Whether that is as a matter of practice true is another matter. Now, without this provision, obviously, English would continue to be the sole language of the law, but post return of sovereignty, the position has not really changed that much, except that the English language is not now the sole legal language, but it's still the dominant legal language. And although Chinese or the Chinese language is used in the courts, especially in the lower courts, but when it comes to the importance of the language for the purpose of the practice of the law, especially in the higher courts, there is still no comparison with the English language. Now that obviously is very unfair to those Chinese citizens in Hong Kong who do not speak or understand English. That is especially the case when it comes to the reporting of decisions of the courts, in the sense that most of the decisions of the higher courts, especially of the High Court and the Court of Final Appeal, are still in English, and many of those are not translated. Not to speak of having translations of equal authenticity as the English version, as it were. Now that position is very unsatisfactory and should be changed. Obviously, there are people who do not want to change, and they would argue that if you change that, then the common law system as a system will be gone, because there's an inevitable link between the English language and the common law. But obviously, I do not agree with that. But one does not have to go in all that. For present purposes, it would suffice if the courts make more efforts to comply with Article 9 of the Basic Law, which requires the court to use the Chinese language as the primary language. And the first thing to do, obviously, is to write more judgments in Chinese, or at least to provide for the English decisions to be rendered into Chinese as well, and to be published, if not at the same time, at least not too long afterwards. After all, Chinese citizens in Hong Kong have to comply with the law, and if you do not do that in time, then the so-called equality, so much pronounced as being of great significance in Hong Kong, would be empty talk. And the whole theoretical arrangement effected by Article 9 would be vacuous. So this is what I would say as far as the present position of the Chinese language in the legal system when it comes to the provision of decisions of the courts in Chinese. That is quite unsatisfactory, and I hope that this will change very soon.